that, I'm excited. We had talked about doing something like this when we met in person in Vegas, and thought that with having a lot of more organized content with these calls, that in some ways we were kind of lacking on just general updates and things that people needed to know. We're obviously very graced to have Leslie Fair now with us in January to give us the annual roundabout. Thought it would be important, at least on a quarterly basis, update as to what's going on that affects our industry in all legal facets, including regulatory from the FTC and state AGs, from self-regulatory, from IRS, and also in that pesky private litigation or class action realm. And so Manatt gamely stepped up and agreed to take on the first of these. And Marc Roth is the organizer of this merry band. Marc is no stranger to anyone in ERA. He has FTC work for many years, including doing a stint at the FTC's Northeast Regional Office in New York. So he not only practices there, he's drunk the Kool-Aid there and really has a good connected perspective. So Marc, I'm going to turn it over to you and your team, and let me just thank you on behalf of ERA for taking this on for us.
Thank you for inviting us to do this, as well as Bill for coordinating. Is very happy and pleased to be presenting the first quarterly regulatory update. Joining today will be my colleagues here at Manatt, LaToya Sutton, Ira Shaw, Lauren Aronson, and Holly Melton. I'll be shouldering the substantive content of the program following some of my introductory remarks and then some closing comments as well. Well, to present on 3 months of activity in our space is very difficult. There's activity, a number of regulatory actions, legislative developments, et cetera, and to capture in word all of it it's undoable. But what I wanted to do was pick out cases that were obviously most relevant to a membership and to elaborate a little bit on how it impacts the DR and the ERA industry. So that's what we've attempted to do here. A lot of content, so we're going to jump right into it and get talking. If we don't cover a topic or a case that you may have heard about, obviously we're happy to, if you bring attention, we're happy to discuss it with you. We are not going to be discussing today various items brought by Pete Marinello and his team during his IRS presentation in February in Orlando. So we will not be covering those topics today, just new stuff that's happened in the past 3 months. My colleague LaToya Sutton to report on federal actions.
Thanks, Marc. And I will just jump right in because we have a lot to cover, and I hope that I don't speak too quickly and everybody can understand me. The first case that I'm going to talk about is with Lumos Labs, who's the company behind Luminosity, which you may have heard of. The company agreed to settle charges that the program deceived consumers with unfounded claims that Luminosity games can help users perform better at work and in school and reduce or delay cognitive impairment associated with age and other serious health conditions. According to the FTC's complaint, they made claims that the apps would improve performance on every task, age-related cognitive decline, and protect against mild cognitive impairment, dementia, Alzheimer's, and also reduce cognitive impairment associated with stroke, PTSD, ADHD, and a host of other medical conditions. The company advertised that these training programs, your youth training programs for 10 to 15 minutes, 3 to 4 times a week would help achieve their full potential in every aspect of life. They were sold online and through mobile app subscriptions ranging from $14.95 to almost $300. As a Lumos Labs will pay $2 and Consumer Region will notify subscribers about the FTC action and also provide an easy way for subscribers to cancel their auto renewal to avoid future billing. The is a $50 million judgment against Lumos Labs, but it will be suspended due to financial conditions after the company pays an initial $2 million to the commission. Next slide. This is about a weight loss product, and that's always one of the FTC's primary focus, so this is not surprising. The defendants, Anthony Dill, Stacy Dill, Direct Alternatives, and Organics, were charged with violating the FTC Act and the Maine Consumer Protection laws in connection with their promotion and sale of the weight loss supplements AF Plus and Final Trim. The complaint, which is both from the FTC and the Maine AG's office, alleges that the defendants falsely claimed users would quickly and easily lose significant weight and reduce their waist size by taking the supplements, and that the results were proven in clinical studies. So used radio ads, at least one of which claimed public service announcements to further sell their products. Also are alleged to have sold the products using a deceptive risk-free trial, when in reality the only way to avoid being charged $9.90 for a minimum order of 2 bottles would earn 1 unopened bottle at the consumer's expense prior to the end of the 30-day risk-free trial, and consumers allegedly not being refunded the initial shipping charge of $7.95. The complaint also states that the defendants obtaining refunds difficult because consumers couldn't get through to their customer supply and encountered resistance trying to get refunds. The makers with deceptively promising $80 worth of Target gift cards to consumers who agreed to trial memberships of 2 buying clubs. They never received the $80 in gift cards and were auto-billed $24.95 per month for each club if they failed to cancel their membership within 3 days. Next. Which I've listed out here are not surprising. They're the typical consumer language we've been seeing in supplement cases where the defendants are banned from making any claims about dietary supplements, OTC drugs, patches, creams, and other products that are worn or rubbed into the about them causing rapid or substantial weight loss, and also prohibits making certain weight loss claims unless they have competent and reliable scientific evidence in the form of randomized, double-blind, and placebo-controlled human clinical testing. There's also a very significant over $16 million judgment. However, it will be suspended after the defendants sell or liquidate a portion of their assets, including real estate, furniture, appliances, snowmobiles. It's really sort of the whole kit and caboodle. Next slide. The next case is about Made in the USA. In February, FTC filed a complaint alleging that the defendant, Chemins Inc., made deceptive Made in the USA claims. They made unqualified claims, such as Made in the USA and proudly Made in the USA, about their glue products, which imply that all the products are all or virtually all made in the United States. The FTC alleges that the claims are deceptive because a significant portion of the cost of chemical inputs to the glues, approximately 55%, is attributable to imported chemicals that are essential to the glue's function, tying back to the FTA's and guidance about how to analyze whether your product qualifies for a broad Made in the USA or 100% Made in the USA claim. And so the FTC is seeking to currently prohibit Chemins from making claims that would violate the Act in this way, and also seeking monetary relief. The case is Butterfly Labs. It's a sub the FTC in February, where the marketers allegedly deceived thousands of consumers about the availability, profitability, and newness of machines designed to mine Bitcoins, and fairly kept consumers upfront paying despite failing to deliver the machines as promised. FTC alleged that DF Labs charged consumers thousands of dollars for its Bitcoin mining machines and then failed to deliver the computers until they were practically useless, or in many cases did not provide the computers at all. So the settlement also resolved charges that the defendants failed to disclose that they were using the machines for themselves before delivering it to consumers. This prohibits misrepresenting whether a product or service can be used to generate Bitcoins or any other virtual currency on what a date a consumer will, or misrepresenting what a date a consumer will receive the product or service and whether the product is new or used. It prohibits upfront payments for Bitcoin machines and also requires the deprived consumers with prompt refund if they sell a damaged or defective product and to obtain a consumer's for delivering a product late. Monetary judgments in the case were partially suspended due to the defendant's ability to pay, but they amount to over $38 million. Next slide. Case also involves a suspended payment, but also illustrates that trying to pull a fast one with FTC is really not a good idea. It's an enforcement action with HCG Act. In 2014, the company and its owner signed a consent order settling charges related to advertising of a weight loss supplement that was entered in an amount equal to the consumer injury of about $32 million, but then suspended and no payment was required. As a part of FTC negotiations, parties have to file financial statements showing how much they can afford to pay. In a typical case, the FTC will then require disgorgement of all or nearly all of the assets that were disclosed. Because this order required no payment, it's safe to consume that the financial disclosure showed that there was little or no ability to pay. However, after agreeing to the no money settlement, the FTC discovered several quote-unquote irregularities in the financial. For example, the owner reported income of approximately $8,500 per month, but in reality it was closer to $30,000. And another example is that the owner stated that companies he partially owned had no financial assets when in reality they were worth between $65,000 and $150,000 in cash. So the FTC, after discovering information, went to court to remove the suspension. And interestingly, the defendants did not deny irregularities, but argue that they were not material. The court denied it, and they dismissed the defendant's argument. So now the FTC is free to collect the $3.2 million. And yes, in late 2015, towards the end of December, the FTC released an enforcement policy statement and business guidance updates on native advertising. If you haven't, read these documents and consulted them, you really, really need to. This is very important in the industry right now. Consumers, the basics of this are that consumers must be able to quickly and easily distinguish sponsored content from content that is independently created and produced. In the guidance document, the FTC only identified a small handful of circumstances where disclosure would likely not be required. So it's really emphasizing that marketers need to look at native content, native advertising, and make sure that they're choosing the appropriate disclaimer. And so there are some of what's considered effective and not effective, and there's also a few things that are a little bit in a gray area depending on the context. But it's interesting that FTC specifically commented on promoted stories being too ambiguous to really consumers that the advertiser was involved in the creation of content. and that policy statement out. Last month, the FTC filed enforcement against Lord & Taylor since it's published those documents. The action followed a highly successful social media campaign launched by Lord & Taylor to promote its private label clothing brand Design Lab. It's a main case, so I'm going to talk through it a little bit. Nine, an online magazine published a photograph of its Instagram account of a certain paisley dress along with a caption. Lord Taylor had edited and approved the post without disclosing the commercial arrangement between itself and Dawn. Now, also ran an article regarding Design Lab, pre-approved by Lord & Taylor, without disclosing that the article was paid advertising content. And the FTC alleged that Lord & Taylor also engaged social media influencers to promote Design Lab on Instagram without ensuring compliance with its guides concerning the use of endorsements and testimonials in advertising. Lord & Taylor gifted the dress to 50 fashion influencers with sizable social media followings and paid them between $1,000 and $4,000 to post photographs of themselves wearing the dress along with a caption. While influencers were contractually obligated to mention and tag the company, they were not contractually obligated to disclose material connections. So none of the posts disclosed that the dress was free, the influencer was compensated, or that it was part of an advertising campaign. Next. So the agreement prohibits Lord & Taylor from misrepresenting paid commercial advertisement as a statement or opinion of an independent or objective publisher or source, and it also imposes significant compliance obligations, including providing each endorser with a clear statement of responsibility, establishing a monitoring system, and immediately terminating any endorser for misrepresenting impartiality or failing to disclose a material connection. Next. And so the very latest is a crackdown on all natural that really just became public earlier this week. He announced settlements with 4 companies that market cosmetic companies products and filed a complaint against the 5th company. Unfortunately and unsurprisingly, what we don't get from these settlements is any more of a definition of the term natural. The FTC's really focus on the use of all natural or 100% natural. So they, again, kind of skirt around the issue of what exactly is considered natural, just making some of the ingredients involved as synthetic. And I have listed out sort of the products and the claims and the ingredients that kept coming up is dimethicone, which is a popular sunscreen ingredient, and ethylhexylglycerin and phenoxyethanol. And so that all sort of allege that these are ingredients that are being products that are promoted as all natural. The 5th company also sells an all-natural sunscreen, and the proposed orders prevent the respondents from misrepresenting whether a product is all natural and the extent to which the product contains natural or synthetic components, and competent and reliable evidence to support any product claim. To the FDA, a couple batches of warning letters that have gone out in the first quarter that are really of interest. The first one involved methylcynthrin, which in late March, FDA issued 7 warning letters to companies for using the ingredient in supplements. It's known for its performance-enhancing properties, and according to the letters, it does not meet the definition of the dietary ingredient, which I have on the slide for you. So the ingredient that the FTC finds is not a dietary ingredient. It's in product that will cause the product to be misproduced. So the letters want these companies to remove that ingredient from their product. Next. in February, the FDA issued 8 warning letters to firms that marketed unapproved new drugs that allegedly contain cannabis oil or CBD, and these follow 6 letters that the FDA issued in February of last year. Really interesting, little-known provision that these products are being warned about. Typically, the FDA warning letters focus claims and the intended use of products. Here you'll see in a section quoted from the letters, if a substance such as CBD has been authorized for investigation as a new drug for which substantial clinical investigations have been instituted and for which the existence of investigations has been made public, then products containing that substance are outside the definition of the dietary supplement. So that's just a quirky little provision they're using to claim that these products are misbranded. And, as cannabis are, made legal in states increasingly across the country, there's a increased market for these products, but, you really have to pay attention to, what regulatory oversight there are on certain products, particularly ingredients such as CBD. Rounding out the FDA update, there's also been a new guidance issued to the compliance guide about omega-3 fatty acid nutrient content claims. In 2014, FDA issued a rule that made all nutrient content claims for EPA, DHA prohibited, and also prohibited some claims about ALA, although some claims are also still available. I won't go into the details of this. Next slide, but we have provided the prohibited claims, the claims that the FDA was previously enforcing exhibiting enforcement discretion, but now they completely can be made. And on the next slide, we've also provided the few nutrient content claims for AA that may still be made. Moving to the CFPB section, we're just going to quickly go over one case, Jola Inc., which was CFPB's first enforcement action for alleged misrepresentations about a company's data security practices, which imposes a $100,000 fine against an online payment company, operated an online payment system with over 650 users, and transferred as much as 50 million per day, collecting sensitive personal information about the users. Allegedly claimed that its social platform provided safe and secure transactions, and that anybody with an internet connection could safely send money to friends and businesses. CFP alleged that the company failed to employ reasonable and appropriate measures to protect this data from unauthorized access, did not implement it, and released applications to the public before testing whether they were secure. Tipped as an surprise, the settlement involved no admission of guilt and the $100 fine, and prohibits the company from misrepresenting its data security practices, and makes it so that they must fix their security flaws, securely store and transmit consumer data, and properly train its employees. This is an interesting case, mostly because it the CFPB itself as in security, something that was previously typically just handled by TC, and that it's also interesting that the CFPB relied upon its authority to challenge unfair or deceptive acts and practices. So there's no actual brief. There's no consumer that was actually or compromised. They really just relied on their regulatory in order to bring action. So I think that is all for me, and I'm going to pass it on to my colleague, Sumaira.
Okay. The state regulatory enforcement side, We have one case that we'll be discussing today. It's an action that was announced on March 10th by the Florida AG's office, a lawsuit that was filed by the Florida AG's office against a time reseller, Prime Resorts International, its owner, who is individually named as well, for alleged violations of the Florida Deceptive and Unfair Trade Practices Act and the Florida Timeshare Resale Accountability Act. The defense in this case allegedly made unsolicited calls to consumers claiming to have ready buyers and renters for timeshare properties. And they claimed to be able to guarantee sales and rentals of those timeshares, and in connection with that, they collected upfront fees from consumers ranging from nearly $100 to more than $4,000, and allegedly they did not have any buyers or renters willing to pay any price for timeshares. The AG received, and the Better Business Bureau actually received 84 more than 5 consumer complaint losses totaling more than $110,000. The lawsuit seeks a permanent injunction, civil penalties of $1,000 per violation, a disgorgement of profits, consumer restitution, and attorney's fees. And moving on to a new BPA warning that's in effect in California starting next month on May 12th. All products containing an amount of BPA must carry a clear and conspicuous Prop 65 warning for reproductive toxicity in females. The notice needs to be placed on product and packaging. There's for products containing less than the maximum allowable dose level, which has not yet been set by the state. This could also impact food and beverage packages, and this warning follows a 1-year grace period that was allowed by the California's Office of Environmental Health Hazard Assessment. Presenting on NAD and ERSP updates will be Lauren Aronson.
The first case that we'd like to discuss is part of the ongoing saga between Dyson and Europro. This time, Dyson went back to NAD challenging Europro for several claims made in an infomercial for the Shark Rocket Deluxe Pro vacuum cleaner. Several claims in the infomercial. The most interesting ones for the audience relate to the real people, real results demonstrations, as well as enforcement and enforcement disclosure issues. Next slide. First, with respect to endorsements, in the real people, real results demonstrations, Dyson argued that Europro did not disclose the material connections between the people featured in the infomercial and the company. She argued, however, that there was no need to make a disclosure because there was no material connection between the endorsers featured in the infomercial and Shark. This was because the consumers were not actually given any product for free, and they were never told that they would appear in a commercial ahead of time. The consumers were signed up for a testing program and were provided with Shark vacuums for a period of 4 to 5 weeks, and Europro reached out to them on a weekly basis to discuss their experiences with the vacuum cleaners. The consumers were told that they could keep the vacuum, and they did not receive anything of value in exchange for a positive review or in exchange for appearing in the commercial. Determined, however, that disclosure of the material connection was in fact required. This was because first, even though they used the product even though it was borrowed, it was still used for free, and using the product for free could impact the weight or credibility of an endorsement. Second, NAD noted that there were multiple interactions between the consumers and Europro over the 4 to 5 week period, and consumers watching the infomercial would not expect that level of interaction between ordinary consumers and a company in a demo that was titled Real People, Real Results. Next slide. The use of a testimonial in the advertisement. Europro took a review that was featured on the Amazon.com website, and they repeated part of the review in the audio. Going from a regular vacuum to a Shark Rocket is like going from a flip phone to a smartphone, and they also provided a visual of the review on screen along with 5 stars. The problem here, though, was that the review was not an ordinary Amazon customer review. The customer here was part of the Amazon Vine program, had received the vacuum cleaner for free in exchange for a review. While on the Amazon website, there was a disclosure that the review was part of the Vine program and that the customer had received free product, that disclosure was not included in the infomercial. Next. with the way the demonstration was conducted. Europe showed consumers vacuuming their carpets with their old vacuum cleaners, which they were apparently satisfied with, and then following up with the Shark Rocket. After the consumers followed up with the Shark Rocket, the dust cups in the rocket were emptied, and in order to show how much the prior vacuum cleaner left behind. Dyson argued that this demonstration was misleading because it conveyed the unsubstantiated message that the Shark Rocket vacuum cleaners are superior in performance compared to the entire marketplace. Not any consumer perception evidence, but NAD agreed with Dyson. First, NAD noted that they'd actually reached a similar conclusion in a prior decision, and secondly, they noted that the depiction of vacuum cleaners cleaning sequentially, as was shown in the demo, conveyed the unsupported message that the second vacuum cleaner was better than the first vacuum cleaner. It was able to pick up debris that the other vacuum cleaner left behind. And because Shark did not have any evidence that the Deluxe Pro cleaned better than all or substantially all of the other upright vacuums on the market, NAD recommended that they discontinue the demo. Next slide. Dyson also was concerned regarding the disclosure of the basis of comparison for parts of the demo. So the Shark vacuum cleaner was shown picking up sand from plush carpeting, and while EuroPro was able to provide substantiation for the claim that the Shark Deluxe Pro was able to remove twice the amount of sand versus the Dyson D6, AS testing actually requires testing on 4 types of carpet. There's an industry standard test for removing embedded dirt from carpets. For this reason, NAD recommended that EuroPro disclose the comparison was limited to the pickup ability specifically on plush carpeting. That we'd like to discuss involved spray paint. So the advertiser here made various claims for its product regarding the ability of the Ultra Cover 2X spray paint to twice the coverage compared to competitive brands. The challenger, Sherwin-Williams, made competing spray paints, and they argued that the claims were unsupported. So you will see on the next slide, the advertiser submitted some testing to support the claims. The testing, however, was problematic for several reasons. First, NAD determined that the advertiser had to test a sufficient number of products in order to make a line claim. The NAD also noted that the test itself had some methodological problems that rendered it completely unreliable. Not only was the testing conducted in-house, there were insufficient controls in order to make sure there wasn't bias. They didn't line the products. Second, it was unclear whether or not they followed the usage instructions for the Sherwin-Williams Krylon products. Third, the results of the test also did not adequately support the 2X cover claim. The testing showed that the Ultra Cover product achieved 2X coverage compared to 47% of the Krylon Color Master products and 51% versus the Max products. But they were not able to show the twice coverage for the entire time. And further, NAD was concerned that the claim also relied on results that were not consumer relevant because the claim was not true for nearly half of the marketplace. The advertiser argued that the claims were still nevertheless supported because, on average, they could support a 2X claim. However, NAD emphasized that a claim must be true for the entire line, not just the average of the marketplace. NAD found that the claims were unsupported, they next turned to the Ultra Cover 2X product name. Normally, at NAD, if you want to get a product name, a recommendation that the advertiser change a product name, you have to have some sort of consumer confusion evidence, like a survey showing that there was confusion regarding the claim. However, the name here was an express performance claim because the 2X immediately followed cover. There was no implied claim here, and for this reason, NAD determined that extrinsic evidence of confusion was not required, and they recommended a name change. We'll see what happens going forward, though, because Rust-Oleum appeals, so we'll see what NARB says in the future. This involves eco-alkaline batteries. Various performance claims at issue here, but we want to focus on the green claims. NAD considered basically a laundry list of green claims ranging from eco-responsible to recyclable, compostable, certified carbon-free. It covered the span of the green guides. Full detail about every single claim. As you'll see on the next slide, NAD spent some time discussing the various claims at issue and focused heavily on the green guides. I'll just talk about the parts of the decision that were notable. For example, with respect to the gradability claims, the advertiser was unable to show that the batteries completely decompose within 1 year of customary disposal, which the green guides require for degradability claims. The advertiser offered to add a clarification so that they wouldn't be making an unqualified degradability claim, but NAD didn't take them up on the offer because the advertiser was not able to provide evidence regarding the battery's actual rate of degradation. The user also made non-toxic claims, and while they could show that the product was non-toxic for humans, NAD didn't meet the burden laid out, the advertiser rather didn't meet the burden laid out in the green guides because they did not have competent and reliable scientific evidence that the batteries are also non-toxic to the environment or landfill claims. The biggest point of contention, however, related to the carbon offset claims. The advertiser made numerous claims regarding the carbon benefits of the product. For example, certified carbon-free, neutral, the only 100% carbon-neutral alkaline battery. And to support these claims, the advertiser offered two types of substantiation. They offered third-party certifications as well as a life cycle analysis. As in the next slide, however, NAD determined that the third-party certifications offered by the advertiser were not sufficient. The green guides require that an advertiser have emission reductions that have already occurred prior to making a carbon offset claim. Here, while the advertiser could certainly show these third-party certifications that they were actually projects that would theoretically the product carbon neutral, the problem was that the advertiser had no information about what those reductions were, whether the reductions occurred, or even whether or not the reductions will occur. So he found that these certifications didn't meet the requirements in the green guides, and they reminded the advertiser that in order to make a carbon offset claim, you're still obligated to have competent and reliable evidence and can't just rely on certifications. A life cycle analysis, but NAD determined that that life cycle analysis was also not competent and reliable evidence because the life cycle analysis was conducted in 2013 in Canada and did not include U.S. distribution or recycling, therefore it wasn't relevant to the U.S. market. As we usually see in these types of cases, the advertiser also made numerous unqualified environmental claims, including eco-responsible batteries, green, environment and landfill conscious, and so on. And the NAD recommended that those claims be discontinued as well because they implied that the products have far-reaching environmental benefits or no negative environmental impact. Agreed to cooperate with most of the decision. Ultimately, the case ended up being referred to the FTC. This was because the advertiser indicated in the advertiser statement that it would not discontinue any of the claims relating to the carbon neutral properties of the batteries. So we'll see what ends up happening here. As you all know, environmental claims, green marketing are FTC priorities. We'll see if the FTC actually ends up, what they end up doing here if they do anything. This one that I'll discuss was an EARTH case. This actually is interesting because it was actually filed in the fall, and it was originally referred to the FTC because the advertiser failed to participate. Afterwards, the advertiser contacted EARTH and agreed to participate, and ultimately they agreed to, they stated that all of the claims would be permanently discontinued, but EARTH ended up issuing a pretty detailed decision anyway. Advertising here involved website and broadcast advertising for home real estate purchase education programs. And in addition to talking about the real estate successes of the spokesperson, Marco Kozlowski, the advertising also claimed that consumers would learn how to purchase property with little or no money of their own, and earnings claims such as Marco saved me $590,000, and extra earnings that indicated possible six-figure earnings, and so on. offered 3 programs to students, and Ernst spent some time considering what those programs were, but ultimately Ernst had numerous concerns with the advertising, specifically because with wealth creation products, regulatory agencies in particular are concerned about messaging that consumers can easily earn with minimal time and effort. And further, Ernst noted that those types of claims can create unreal expectations. With respect to the claims that consumers could earn without laying down their own money, Ernst noted that the advertiser did not demonstrate that consumers with little or no experience can typically engage in real estate transactions without laying out their own funds or making a profit. And further, with respect to the degree of effort claims, Ernst cautioned that advertisers should not communicate that consumers could earn money without investing significant time and effort. Ernst also had concerns with respect to claims regarding spokesperson success. Ernst said that these claims can easily communicate the message to consumers that they can also achieve the same level of success as the spokesperson. And with respect to the testimonials, Ernst gave some guidance regarding the type of competent, reliable evidence that the reporter would be required to show in order to indicate what results the average purchaser could expect to receive. Ernst said that when evaluating what the average purchaser can expect to achieve, the advertiser would be required to conduct a thorough follow-up analysis with a representative sample of product users, and that the assessment should take into account the variables that might actually impact the outcome. For example, the number of hours that the endorser spent, how long that endorser participated in the program, whether or not the endorser might have had some experience in their background that might have indicated a likelihood of success, the real estate market in the area, and other factors that might impact the earnings in the testimonial. Ernst cautioned that the product users, that featuring only product users that have earned a significant amount of money without disclosing generally expected results would commit that all users will achieve similar results. As I noted at the beginning, this case was ultimately administratively closed, but there's still some guidance for anyone thinking about how to best structure what would be typical results for these types of claims. And with that, I turn it over to Holly.
Good afternoon, folks. Holly Melton. I'm going to be talking briefly about some interesting developments in the class space. So the first case that we'll discuss is the Campbell-Ewald decision, Campbell-Ewald versus Gomez, which was a Supreme Court decision. For background, the plaintiff had brought a putative class action based upon receipt of an unsolicited text message, and so sued pursuant to the TCPA. And before he made his application for class certification, Campbell-Ewald tried to sort of cut him off at the path, offering him a settlement that would be slightly more than what he would otherwise be entitled to collect in statutory damages. The plaintiff refused that offer, and then, of course, the defendant moved, in this instance, moved to dismiss the claim based upon this sort of he wouldn't collect more, wouldn't be an appropriate class representative, and therefore the case should be dismissed. The Ninth Circuit disagreed with that position and said that the plaintiff's claim could go forward, and that decision was ultimately appealed to the Supreme Court. In January of this year, the Supreme Court determined that an unaccepted offer of settlement or an offer of judgment is not going to foreclose or moot a class action plaintiff's claim. And so merely offering the person a settlement value that would fully satisfy their statutory damages claim in this instance would not be enough to prevent that class action from moving forward. What the court did not indicate was whether or not actually payment of the amount of the class representative's damages would be more effective. That case dismissed. And so since that decision, next slide, there have been some there have been some sort of mixed opinions in terms of whether or not that strategy would be effective in scoring a class action. So in Beatty versus Basic Reach, which was filed in the Eastern District of New York, this was a CPA case. It was basically a claim, a false advertising case about the safety and effectiveness of certain weight loss pills. And whether or not they were in fact effective in controlling weight and controlling appetite. In this instance, the defendants made an actual offer of judgment under Rule 8, and then made a move under Rule 67 of the federal rule to deposit those funds into the court, intended to thereafter move to dismiss. But the motion to deposit the funds into court was actually denied. And the judge noted that if a class representative has a live claim, they have to be afforded their day in court, and you're not going to be able to do an end run, at least in the Eastern District of New York, by making a motion under Rule 67. Next. Different outcome in the Southern District of New York. This was the Lease versus Lifetime Entertainment Services case. There, this was another TC class action. The plaintiff brought a claim because there was an unread message left on his machine, and he claimed that while his was a Time Warner subscriber, he was not, and therefore had not authorized to be contacted by phone. But he didn't. Lifetime did want to get him the very important information that Project Runway was not going to be was going to be moving to Bravo. He did not have information, however, and brought a class action. The defendant in this instance took this, sort of Campbell-Ewell decision and thought, okay, I'm going to offer a full settlement that's going to satisfy all state the statutory damages. Deposit funds, or intended to deposit those funds, but moved to dismiss rather than making the Rule 67 motion. And that was successful. The court in March of this year determined that the motion would be granted as soon as the defendant deposited funds into court. What was interesting here, and what may be, a bit of a distinction between the two situations, is in this instance, Mr. for class certification had already been denied, and so in that instance, really just his single claim as opposed to him being a class representative. So not that was the reason for the difference, and will be further fixed as there are more and more decisions on this issue. Next slide. So the next in the class action space for the first quarter is there's been a number of deceptive pricing class actions and decisions in the space. So the first one is the Adame case, which was a guess, and the plaintiff's claim was that it was tagging items in outlet stores and indicating a very high inflated, suggested retail price, and then offering the product a significant discount off of that price. And the plaintiff argued that those prices had never been relevant in any store, that no person had ever paid that suggested retail price, and as such, this is where this inflation to sort of induce folks to think they're getting a great deal and buy these products. The defendant moved to dismiss, and this was, again, a California case, so it was the California Unfair Competition, False Advertising, and then the CLO. The motion to dismiss was denied in March of this year. The court determined that the plaintiff sufficiently alleged intent to deceive, instances of actually misleading behavior, and a potential injury to the consumer. There was also a motion to strike the classifications, but that was denied as well. So that's news. Next slide. There was also activity in against Burke. So actually, this is a number of cases, I'm sorry. There are a whole host of class actions filed in February of 2018 this year that are making very similar claims to that of the Adame case. The claims were against very prominent retailers, including Burberry, New York & Company, Children's Place, Dooney & Burke, and Coach. And it's essentially the same allegations. It's making a representation that the product had been sold at a significantly higher price that the plaintiffs argue is inflated purposefully to create the illusion of a significant discount. In fact, at least according to the plaintiffs, nor had ever sold the products at that price, and are therefore designed to deceive consumers into believing that they're getting a great deal when in fact they aren't. So hasn't been activity in these cases since they were just recently filed, but stay tuned. We'll turn it over to Mark.
Thanks, Holly, and Myra, and Lauren, and Toya. We'll kind of close up today with kind of like a bonus round here. In addition to the various matters that are the past 3 months, we've also been seeing some trends that some are resurgent of new issues, and some are some old issues, and some are some new issues that companies are facing. The first that I have here is the enforceability of a website terms of use. Every company that sells online has a terms of use and a privacy policy. And the extent to which a terms of service or a term of use can actually be enforceable will be by the extent of the consumer involvement in how they interact with the terms. So, for example, there's a distinguishing factor here between click wrap and browse wrap agreements. Browse wrap are a terms of use link at the bottom of a page where a consumer does not necessarily need to agree to them. Any page that you surf, it may be subject to those terms, but you're never required to agree to them. A click wrap, on the other hand, requires a consumer to click something or to take some action to consent to those terms. It's all questionable whether or not they're required to read them. So the spectrum of how terms are presented to a consumer, on one far end you have browse wrap, where we're not decide to look at required at it at all. Moving more towards the middle, you can have something that says your use of this site is subject to our terms. Someone perhaps press submit or agree. On the other far end, you can have, well, the extreme far end is something like the Apple iTunes terms, which each new version, they are disclosed to the user, and you have to scroll through them and presumably read them all and then agree. But for most common websites, it is merely just a checkbox, which is where accompanied by a statement that says, I have read and agreed to the terms above. So, read a number of cases where consumers have brought class actions, claiming allegations of Fair Credit Reporting Act or UDAP laws, where the defendant then sought to stop the class action by compelling arbitration as provided in terms of use. The cases have come out across the board based on the extent to which there's consumer involvement in those terms. I have a couple of examples here, and courts in the TransUnion case in the Seventh Circuit said it's a reasonable communicativeness test, which means, is there enough communication between the consumer and the company on the website to agree to the terms? In Long versus Divide Commerce, also another recent case, last month, a link to a terms at the bottom of the page is not enough to put you on notice that dispute between the parties shall be subject to mandatory binding arbitration. So in the latter case, Provide Commerce, they lost on that motion to compel arbitration because they did not require a more interactive engagement with the consumer. Here, as I just mentioned, on the spectrum, if you have an unchecked box accompanied by agreement language, says I have read and agree to the terms. And you may not have to have an exact checkbox, but if you have a disclosure in Committee 2, and preferably above, the or purchase button to say I have read and agree to the term use and privacy policy, with the term use as hyperlinked so that the consumer can easily click on the link and they see the terms in front of them. Even that, which I didn't get into on the slide, is to, at the beginning of those terms, is to have some statement that says this document contains important information about your purchase, including of a right to participate in a class action and mandatory arbitration. Please paragraph X below. The paragraphs are typically not at the top, but any reference towards the top would probably be advisable. The second is a new law that, not really a new law, but a law that is emerging now in the class action space. I admit this at the Legal Affairs meeting in Orlando, is just beginning and to come to the forefront, and now a lot of activity. There is the Truth in Consumer Contract Warranty and Notice Act. Decades-old law that prohibits the provision or display of any written warranty, notice, or sign that includes provision that violates any clearly established legal right. And I want to hold on to those words for a second. Of a consumer established by state or federal law at the time the offer is made or the consumer contract is signed or the warranty notice or sign is given or displayed. TCPA, which we all know and love, it provides a $100 statutory civil penalty or actual damages. Even actual harm or even reliance on the posted notice is proven. There's a number of law firms now, primarily there's a couple in California and some actually in New Jersey, that are bringing cases on behalf of plaintiffs alleging that a website terms of use itself violates this law because of exculpatory provisions, such as we disclaim any responsibility for the product or for the service, we will not have liability, and various other disclaimers. To date, there's not been a lot of cases in this area, but there have been enough to kind of give us some idea of the type of matters that courts are allowing to go through. And I think, and just based on the current docket of number of cases being brought, these cases are only going to continue to grow, and in time we're going to have a more robust body of precedents to rely on. There's a lot more details and a lot more nuances here that I have time to go into, but I just want to make everyone aware of this law, to watch out for it, to review your terms of use, to see to what extent they may possibly be considered in violation of the state law. A number of our clients and other companies have been receiving pre-litigation letters and lawsuits, but one of the important things to do is to see if you do have a binding arbitration agreement, provision in your terms of use, to what extent consumers have to agree to it, because we had some success in react to plaintiffs' pre-litigation letters saying that, thank you for bringing this to our attention. However, as you know, there is a mandatory arbitration provision in the terms of use, which, by the way, has also been upheld by the Supreme Court in AT&T versus Concepcion, and the consumer who purchased on this website had to agree to these terms. That has been successful, at least in pushing off some of these claims. Who knows if they come back and try those cases. In the presentation for today, we thank you very much for participating, for listening in, and as always, if you have any questions about any of these matters, myself and my team here are happy to assist. And thank you, Amy and Bill, for having us present today.
That was very impressive to have that many people participating and have it really stick to the hour. That's some fantastic coordination by that Manatt team. I know we are at the end of our time together, but is there anyone on the call who would like to ask anyone on the Manatt team a question about the presentation from today? I just want to give my thanks, kudos to you, especially in addressing the natural case. I mean, I think those natural cases, the natural case came out like 2 days ago, so you guys really put thought into this, and up until the last minute to bring us really up to date this past quarter. So we're very grateful. And with that, we will end our meeting and hopefully see everyone at the fly-in on May 24th and 25th. Thank you very much, everyone.
Thanks, everybody.